This week in the Boardroom, brought to you by corporate board member and host NYSE Euronext, along with governance knowledge partners, the Center for Audit Quality, and Grant Thornton, and contributing partners, National Investor Relations Institute, and the Society of Corporate Secretaries and Governance Professionals.
Welcome to this edition of This Week in the Boardroom. I'm TK Kerstetter with the NYSE Governance Services Corporate Board Member, and I'm joined today with my co-host, Scott Cutler, who is the EVP of Listings and Capital Markets with the NYSE Euronext. Welcome, Scott.
Great to be here.
We're going to talk about the Delaware courts and an important bylaw ruling, and to make sure that we understand this well enough, we're bringing back an old friend, somebody that hasn't been on the show for a couple months, but we're happy to have him back, and that's Stephen Lamb, who's currently a partner with Paul Weiss, but is also the former Vice Chancellor of the Delaware Court of Chancery. And Stephen, it's great to have you back.
Great to be back with both of you.
Well, you know, directors are busy people. They don't always have time to sort of keep track of all the legal things that are sort of happening that impact their boardroom. But this ruling that came up in June that I believe was directly associated with Chevron and FedEx, which were two companies that were involved with this, were cases where their bylaws, something that they had in their bylaws gave them flexibility for, you might say reducing some risk, but certainly reducing costs and some frustration. This is something that's potentially good for the shareholders, but there's a group of shareholders that probably are opposed to this. Can you sort of recap the bylaw and what these companies were saying and how the shareholders feel?
Sure. I mean, the issue is where litigation that is brought inside the corporation, what we call internal affairs litigation. So suits by the shareholders against the directors for breach of duty arising in M&A transactions or in executive comp circumstances, what are generally derivative litigation. It could be either a derivative case or a class action case, and things like that. But the question is, where are those suits brought? And often people bring them in the Court of Chancery. The bylaw that was adopted by Chevron and by FedEx is one that required that those lawsuits be brought in a Delaware court, either in the Court of Chancery or in the United States District Court for the District of Delaware. And the reason behind this, and it's been a movement for the last 4 or 5 years to explore this topic, is that increasingly we've seen cases where suits are brought outside of Delaware that should be brought in Delaware, you would think, or where there is a multiplicity of litigation. There's litigation in a merger where that you might have 3 different venues. You're sued in your principal place of business, you're sued where you have your executive headquarters if it's different, and you're sued in Delaware. And it just creates a lot of duplication of costs. It creates a real management issue. And frankly, it also sort of creates problems in the law because of the necessity to manage these 3 different lawsuits. So there's been thought that a bylaw, either adopted by the board unilaterally, where the board had that power, or by shareholders, or even a charter provision could be adopted that would require that all that litigation be brought in Delaware. And Chevron's board adopted a bylaw like that, and FedEx's board did too. Maybe 15 or 20 other companies, a number of other companies did as well. Many of them were sued in the Court of Chancery. A lot of them withdrew the bylaw just to avoid the litigation, but these 2 went on, and they won. And so the Court of Chancery held that the bylaw was valid under the statute, which was one question, because you might have thought bylaws, or the argument was that bylaws only related to sort of regulating how people did things inside, how you had your meeting, how the board met, how the shareholders met. But the court held no, this was a valid exercise of the bylaw power. And the court also held that even though it was only adopted by the directors, that it was a valid, essentially, amendment to the compact between the shareholders and the corporation. And so the court upheld this bylaw.
So the court upheld this exclusive forum provision in the Chevron and FedEx cases, but it only applied to internal affairs instances. So it not with tort claims, federal securities laws violations, general commercial litigation.
Oh, absolutely.
So it's
right.
it really help our viewers understand internal affairs cases. It's just limited to those types.
Yes,
correct?
it's suits that generally arise under the Delaware, either the general corporation law that regulates how the corporations do things like issue shares or hold meetings or that sort of thing, or that arises just out of the general fiduciary duties that directors and officers owe to the corporation, and in some cases to the shareholders directly. And cases that arise in that context, so it's regulating really the internal workings of the corporation.
So when a plaintiff or the plaintiff bar previous to this would bring suits in jurisdictions all around the country, and is the purpose of that is that there's just millions and millions of dollars of defense and people settle, or is it trying to find a good jurisdiction where somebody's going to give a favorable ruling?
I think it varies. For example, in the executive comp cases that have been brought recently since we had the say on pay votes. So you'll recall we had a show on this, I'm sure, a while ago, that after say on pay votes that either were very close or lost, people were filing lawsuits, suing the directors for breach of fiduciary duty, for having approved these things. Even though the federal law says expressly in it, this does not create or change anyone's fiduciary duties, right? Those cases were all brought outside of Delaware, even where they involved Delaware corporations. And the reason, quite plainly, was because they knew if they brought it in Delaware, they would have been out of court in a week or a month. I mean, it wouldn't have lasted a heartbeat. So those cases were brought looking for a more favorable forum. Now, most of them didn't find it, but they tried. Many of them are brought because someone else has already filed in Delaware, and so you're a plaintiff's lawyer and you're looking for a piece of business, so you can't either come to terms with the lawyers in Delaware who are already there, or you want to stake out a stronger position, so you file someplace else. And it creates management problems for everyone, for the courts and for the parties.
So if you are incorporated in Delaware, and the benefit to a corporation in having an exclusive forum provision is to have one forum where all these issues are brought to bear, you know what you're dealing with. It seems like, from you, TK had mentioned, from a cost and efficiency standpoint, there's a benefit. Why would not, after this, every corporation, or should every corporation put in place an exclusive forum provision?
I think everyone should look at the issue. I mean, the only negatives at the moment are this is just a trial court decision. We still have to hear from the Delaware Supreme Court. And then once Delaware has spoken, we still have to hear from courts around the country whether they're going to, when the case is brought in Illinois, is the Illinois court going to give effect to this provision in the charter to dismiss the case in Delaware? We don't know yet. There is a case in the federal court in California a year or two ago that refused to do that, because it was a different circumstance. It was a bylaw adopted by the board, and they were trying to apply it to some conduct that had happened beforehand that they already knew about. And there were circumstances where the court said, I'm not going to do it. But I think in light of the decision that Chancellor Strine gave recently, courts around the country are very likely to give effect to these. Certainly in jurisdictions where they give effect to contract provisions, choosing forum, they should give effect to this too. But that's an issue. It's still likely, it's not clear to me that these same plaintiffs aren't going to sue the next people who adopt this bylaw until the issue is finally resolved. So you'll have that problem. And then the other issue is that ISS has taken, and Glass Lewis both have taken positions more or less against these provisions. ISS has a strange position, I think, which is they don't think you should be able to adopt one of these unless you personally, your corporation has already suffered having to engage in litigation in multiple jurisdictions at the same time on the same issue. I mean, it isn't enough for them, apparently, that it's a common experience and that you should take prophylactic measures so that it doesn't happen to you. Their position is that somehow you already have to have paid the price before you can have this bylaw. So,
is there any argument that they're making that these sorts of provisions shouldn't be by written consent, but they should be approved by shareholders as well? Where is that settled in this case as well?
Well, this case certainly settled the question whether it was permissible for a board that had the power to adopt bylaws to adopt such a bylaw, and the court said yes. I think lingering in all of the opposition, there probably is some sense that you should put it to a shareholder vote, but we'll see how that. I mean, that hasn't survived this case, at least in Delaware, as a matter of law.
Well, that's something we're going to have to watch, because it seems like if that does advance, and here's a case where the shareholders, there's got to be a lot of shareholders say, all that money moves to the bottom line. This is good for me as a shareholder. And then there's those that bring suit that say, I want to have that. So there's some conflict there even among the shareholder ranks.
I would think most shareholders would be in favor of this, because if you want to be a shareholder in a Delaware corporation, you ought to be willing to have your cases decided by Delaware judges. And it is true that there are shareholders bring lawsuits, but the economic interest in it more is the lawyers bringing the lawsuits, not the shareholders. But there is another. So the shareholder attitude toward it is important. So for any corporation thinking about doing this, it is important to know whether you have some really entrenched opposition to this in your shareholder group. And if you do, then you do this at some risk.
We've got about a minute left, and we want to take advantage of you being here. So is there anything else that you sort of see in the works or on the horizon that affects the boardroom and our viewers that we should at least tell them to be aware of?
And maybe you've already talked about this, but maybe you haven't. There was a case decided again by Chancellor Strine in June or May or June, called McAnderson Forbes Worldwide, M&F Worldwide. It involved a going private transaction where McAnderson Forbes owned 35 or 40% of the business. They went to the board and they said, we want to make a proposal to buy the whole business. We tell you right now in writing that we will not do a transaction unless it is approved by a special committee of independent directors, which is fully empowered to hire lawyers and bankers, fully empowered to say no. We tell you we're not interested in selling our shares, so there isn't much point in trying to shop it. And we also commit today in writing that this transaction will have to be approved by an unwaivable majority of the minority shareholders. And they went through with the transaction on those terms. The committee did its work. They reached an agreement. They got the vote. And Chancellor Strine, on a motion for summary judgment, held that it was that he would apply business judgment review to the transaction rather than entire fairness. So it's a striking result, and one which is, again, it is already in the Supreme Court, but it answers a long question of, it always was, if you had the special committee, you got some benefit in the entire fairness review, or if you had the vote, you got the same benefit, but if you had both of them, you didn't get any extra benefit. And entire fairness review can lead to many years of litigation. It's very expensive. It can't be settled in any reasonable sense. Certainly it's not subject to being dismissed. So this is a sort of middle path, trying to find a way to allow these transactions to go forward.
Stephen, you're always a bright light on having us look at areas that, again, most directors don't have time to keep up to speed with. So we appreciate you joining us today.
My pleasure.
And that will conclude this edition of This Week in the Boardroom. We hope you'll join us next week when we'll take a look at another critical topic that'll help you be a better board member or committee member. We'll see you then.
Join us again next week for This Week in the Boardroom, brought to you by corporate board member and host NYSE Euronext, along with governance knowledge partners, the Center for Audit Quality and Grant Thornton, and contributing partners, National Investor Relations Institute and the Society of Corporate Secretaries and Governance Professionals.